United States versus Miller, 1939. Was there ever a more contentious United States Supreme Court decision that involved firearms? Because depending upon how you read it, either you and I have no right to own any firearm, period, or we get recreational nukes. Both of those positions can't be right. We already went through the whole crazy background of this case in another video, linked in the description box below, and hopefully you'll see that pop up on some sort of card as we go through here. So in this particular case, what we're going to be covering is, what did the United States versus Miller Supreme Court case actually say? How did the anti-gun crowd attempt to hijack it? What was arguably the pro-gun overread? And where are we at it now in present day? How does it exist and what's the future of it? So guys, let's get into it. Okay, so let's start off with, what did Miller actually say? And keep in mind, it's a very short decision. I'm going to be linking that down in the description box down below. For those of you who may have missed the background, here's the really quick one. Two gangsters got caught with a Stevens 12-gauge shotgun where the barrels were less than 18 inches. Therefore, they were in violation of the 1934 National Firearms Act that mandates that you have to purchase a $200 tax stamp for these firearms. They were subsequently caught as they crossed from Oklahoma into Arkansas, were charged in federal court. The charges were ultimately kicked, yada, yada, yada. We go up to the U.S. Supreme Court, actually directly from the federal district court up to the U.S. Supreme Court. Crazy background. Check out that video because you will not believe the background on this. Lots of conspiracy theories here, and I'd say justifiably so. In the United States Supreme Court, we are talking about two big legal issues. First, whether or not the National Firearms Act is not a revenue measure, but an attempt to usurp police power reserved to the states, and therefore it's unconstitutional. Second, whether the National Firearms Act offends the inhibition of the Second Amendment to the Constitution, which of course reads that, quote, a well-regulated militia be necessary to the security of the free state, the right of the people to keep and bear arms shall not be infringed. That's a direct quote from the U.S. Supreme Court in Miller, the offense and inhibition. In layman's terms, whether or not it's a violation of the Second Amendment. That's fundamentally what that's talking about here. So let's pick up with number one. And the reason why I'm starting there is for two things. Number one, I know you clicked on this video for number two, and that's the way bigger thing, and I want to get into that at length. But at the time, people were not really thinking about this so much as a Second Amendment case. People were much more worried and much more critical and much more dubious about whether or not this would be deemed to be unconstitutional, not on Second Amendment grounds, but in essence on 10th Amendment grounds. This was the big issue at the time, whether it was a usurpation of the police power reserved to the states. For those of you who may not recall 8th grade civics class, the 10th Amendment broadly stands for the principle that the federal government does not have unlimited powers. I mean, the whole Constitution, our history, everything stands for that premise, but the 10th Amendment specifically stands for the premise that rights that are not delegated to the federal government are reserved to the states or the people. How does this tie in? The National Firearms Act started as a tax. Then it made it a crime to not pay that tax. That seems a bit like an end around state police powers, right? After all, can the federal government just create a tax for anything that it wants, that it doesn't like, that it wants to regulate to some degree, whatever it is, and then start throwing people in prison for not paying those federal taxes? And of course, that's assuming that you could pay them in the first place. So you can start to see the nifty little trick that people were understandably very, very, very concerned about whether or not, hey, rather than Congress addressing an issue head on, which it may not have the power to do so, what if it just starts creating federal taxes for everything and then can backdoor regulate and then ultimately imprison and suppress people that way? So that's, in broad strokes, what people were constitutionally very concerned about. To this point, the court said, look, the National Firearms Act is not a usurpation of police power because of a 1937 United States Supreme Court decision called Sonzinsky versus U.S., where a firearms dealer was selling National Firearms Act weapons in Illinois. They challenged the NFA. They got charged. They wound up all the way in the United States Supreme Court. Now, since I'm not covering every single U.S. Supreme Court case that I'm referencing in this video. If you want to see me make a video about Sonzinsky, let me know. I'd be happy to do so. Otherwise, you will find a link for that down in the description box below. But just to let you know, you're not missing much, because just the amount of time I've spent talking about Sonzinsky is actually more time than the United States Supreme Court in Miller spends talking about Sonzinsky. They basically just cite to this 1937 Sonzinsky case and says, because of Sonzinsky, we're done. Issue number 1 disposed. So you're not missing anything from the Miller case itself. Again, linked in the description box down below. So the main issue that you clicked on this video for was the Second Amendment issue. How did the Supreme Court reconcile the National Firearms Act of 1934 and the Second Amendment, and what has come of all that since? In a nutshell, the court said that a big purpose of the Second Amendment was to assure the effective training and equipment for the militia should they become necessary for a defense. In that view, the court noted that there is an absence of short-barreled shotguns. Again, short-barreled shotguns, SBR, that's what these guys with these gangsters were arrested for in Arkansas, okay? That there's an absence of short-barreled shotguns being used as ordinary military equipment by the armed forces at that time. And 1 + 1 = 2. And therefore, they said that this is not a violation of the National Firearms Act, since the military does not ordinarily use short-barreled rifles. Now, the court goes on and rattles through a bunch of quotes about different state militias and all this other kind of stuff. And that was basically it. Again, painting in broad strokes. Now, I have a video coming where I'm actually going to be reading various Second Amendment cases, including Miller, Heller, the Bruen decision, and so forth. Different videos, one for each one. I'm going to be prioritizing that project as people let me know in the comment section down below. I consume an enormous amount of written, like books on tape, stuff like that while I'm driving, traveling. So it occurred to me, I don't know if there's really a great accessible spot for this kind of stuff. So if you guys would like that, let me know down in the comment field down below. I can bump that project up. I've already filmed, I think, about an hour and change of one of those big decisions. So it's something we're working through, but these are not short decisions, guys. So help me out if that's going to help you out. There are some things to like, and there are definitely some things to hate here with the Miller decision. Now, the pro-freedom crowd grabs the court's reasoning surrounding short-barrel rifles not being used in the military to understandably and predictably argue that while I may not have a right to a firearm that was not an ordinary military application, that means that I absolutely have a right to all firearms ordinarily in the military. So bring on the automatics, bring on the rocket-propelled grenades, the tanks, the intercontinental ballistic missiles, the recreational nukes, you name it. If the military's got it, and if it's ordinary, it's free game then. That's, I think, a very, very understandable reading of the Miller case, because it's all but a direct quote. Put a pin in that. We're going to get back to this. The anti-freedom, pro-gun control crowd attempts to use the Miller case to hijack the Second Amendment in its entirety, to show that the Founding Fathers had no intention of granting anyone individually the right to keep and bear arms. Instead, the gun controllers argue that Miller shows the Second Amendment only means to guarantee the right of the government, including states, to establish a militia and for that militia to be armed. After all, the court made zero mention, as they point out, of any individual right to keep and bear arms and focused exclusively on this notion of an organized militia in the Miller decision. In fact, the court quoted the Constitution giving the powers to Congress to call forth the militia before going on to say that the Second Amendment, quote, must be interpreted and applied with that end in view, end quote. We obviously have two very different readings of the Second Amendment that comes out of Miller. And could they be any further apart on this issue? Modern day gun control legal arguments have evolved since then, to the point where anti-gun legal scholars have claimed since the 1960s in legal textbooks everything from the fact that it's doubtful whether the Founding Fathers had anything in mind when they wrote and passed the Second Amendment at all, to the fact that it was only a collective right, a corporate right for the states to have an organized National Guard that was allowed to be armed under the control of the state and ultimately Congress. Be sure to stick around to the end because you will see exactly how the court in Heller uses Miller to set up everything about the current Second Amendment right now. I'm going to summarize this for you very succinctly, very concisely as we move through, but it's important that you see the step by step, the brick by brick as to how we get this house that we all live in. So be sure to stick around and be sure to hit that like button. Now back to the video. Now, for a generation who just fought a Revolutionary War triggered by gun control, the little battle called Lexington and Concord, that were deeply skeptical of a disarmed citizenry, this seems on the outset like a dubious proposition at best. But the United States Supreme Court, at least their guns when it came to the Second Amendment, fell silent after 1939 and the Miller decision. It was not until 2008 in a little case called DC versus Heller. In Heller, we're not going to cover everything in Heller here. We're only covering how it applies to Miller and how Miller extends through. In Heller, Justice Scalia, who wrote the majority decision, pointed out that Miller and his companion were charged of being in possession of short-barrel rifles, not because they were bearing any arms outside of military use, but because they were bearing a specific type of arm. Now, I want to be clear. I am getting this from Heller. This is not Tom Grieve evangelizing. This is how it ought to be, according to me. I'm saying this is how it be. Quote from Heller. It was that the type of weapon at issue was not eligible for Second Amendment protection, in the absence of any evidence tending to show that the possession or use of a short-barreled shotgun at this time has some reasonable relationship to the preservation or efficiency of a well-regulated militia, we cannot say that the Second Amendment guarantees the right to keep and bear such an instrument, end quote. That's Heller quoting Miller. Emphasis on the last few words, such an instrument. The key to Miller for Scalia, the key to Miller for Heller, and for law in its current form is that the Second Amendment does not protect every weapon, every time, everywhere, for any purpose. Again, that is Scalia saying that, not me. Scalia correctly points out that if the proper view of the Second Amendment was that it was only to preserve the National Guard, then it would have been sufficient to basically say in Miller, look, we got two crooks. They're not part of the organized militia as part of active on-duty service. Therefore, we're done. By the way, the Oklahoma National Guard was founded in 1895. Arkansas National Guard founded in 1804. These were well-established entities at the time of the offense in the 1930s. Heller, in essence, baptizes the Miller decision into a new order of Second Amendment case law, the order that we live in today, with Miller, McDonald, Catano to a degree, and Bruen. But really, the Holy Trinity, Heller, McDonald, Bruen. And if you just had to go to Heller, Bruen decision. It demonstrated that Miller was never trying to answer the question of what the Second Amendment was about or what it was for. Miller was never a categorical summation of this is what the Second Amendment is. Rather, Miller was simply standing for the premise that, according to Scalia, not every weapon was protected by the Second Amendment. Now, this would turn into Scalia and the court resurrecting and possibly contorting to a degree, subject for another video at another time, an old misunderstood doctrine from English law concerning dangerous and unusual weapons from the old affray laws. Again, broad strokes, not what we're talking about right now. Okay, so where does that leave us, though, with recreational nukes and machine guns, right? Scalia would say, no. I mean, that's bluntly what Scalia says. What the court says on this is, if you read the phrase in Miller that says, quote, part of ordinary military equipment, end quote, then it could understandably and perhaps absolutely mean that only those weapons that are useful in warfare are protected for civilians like you and me to own. However, Scalia goes on to declare that, and I quote, That would be a startling reading of the opinion, since it would mean that the National Firearms Act restrictions on machine guns might be unconstitutional, machine guns being useful in warfare in 1939, end quote. So you're starting to see why I'm pretty down on machine guns and the National Firearms Act in general being ruled unconstitutional by the United States Supreme Court. Even Scalia would not go for it. How are we going to get 5 votes? Again, pushing on. Instead, according to Heller, the Supreme Court in Miller, when it says ordinary military equipment, must be read in tandem alongside what comes after it. Quote, ordinarily, when called for militia service, able-bodied men were expected to appear bearing arms supplied by themselves and of the kind in common use at the time, end quote. What does that mean? All right, just stop what you're doing right now. There are 2 massive, huge, big points that come from that quote. I'm going to read it again because this is so incredibly big. Hopefully I have your attention. Miller said, ordinarily, when called for, militia service able-bodied men were expected to appear bearing arms supplied by themselves and of the kind in common use at the time. So we know that Congress could and can call forth the militia. Who are these people? Well, the traditional militia was formed from a pool of men bringing arms in common use at that time for lawful purposes like self-defense. In the colonial and Revolutionary War era, small arms weapons used by militiamen and weapons used in defense of person and home were one and the same, Scalia points out. This means that, ready? 2 big points. 1, this means that ordinary people absolutely have a right to bear arms. In other words, Second Amendment, individual right, disconnected from militia service. Number 2, this means that ordinary weapons are protected by the Second Amendment. The court says, quote, we therefore read Miller to say only that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes such as a short-barreled shotgun, end quote. So they're saying ordinary weapons are protected. Unfortunately, they're also going out of their way to say that short-barrel shotguns are not ordinary weapons, or at least they were not back in the 1930s. The Bruen decision in 2022 would go on to basically buttress this reading by quoting both Miller and Heller in the exact same manner. There you have it. The big takeaways from Miller. Again, to summarize them, because this is so important. The court utilizes Miller to inductively show that along with a library of other evidence, not from Miller, the Second Amendment is an individual right and not a right for the government to have an organized militia. And 2, that the Second Amendment protects the right of ordinary people to possess ordinary arms. And with that, the Miller case is brought to a close. It has been folded into a lineage of growing Second Amendment jurisprudence and law and given its proper place and rank in that line. What do you think about all that? What do you think will be the outcome of some sort of inevitable challenge to the National Firearms Act? Do you think Miller, and for that matter now, Heller, is going to come back to bite the forces of pro-gun in the butts? Or do you think that somehow this can be, the day can still be won? Do you think that short-barrel rifles, short-barrel shotguns, suppressors, machine guns, AOWs, destructive devices, you name it, will be found to be legally protected arms someday under the Second Amendment or not? Because this case, of course, involves gangsters, I have to take the opportunity to use a quote both about gangsters and the Second Amendment for our quote of the day. Before I do, be sure to hit that like button if you've not already done so. Here's the quote of the day. Quote, and remember, where you have a concentration of power in a few hands, all too frequently, men with the mentality of gangsters get control. History has proven that. End quote. It's from Lord Acton. I appreciate you sticking around this long. That means you are definitely not a gangster. And I'll see you in the next one. I appreciate you sticking around this long. That makes you a gangster. No, let's definitely not use that. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.